I've looked at them.
Thank you. Do you recognize these documents?
Yes.
Let's speak first to document 4. What is document 4?
That's a screenshot of the electronic version of the legal research file.
Is that a folder that you would have populated with research?
Yes.
Did you take part, to the best of your recollection, in doing the research and putting research in that folder?
Yes, at least some of it, yes.
I'm going to draw your attention to document 5. Can you tell me what that is?
That is a subfolder, a screenshot of a subfolder within the legal research folder of different cases.
And can you tell me what the subject of that legal research is?
Yeah, it's called Opening the Door.
Turn to document 6. Can you tell me what the title of that folder is?
Okay. Prior consistent statements. It's another subfolder.
And document 7.
That is a screenshot of a subfolder also in legal research called, should I tell you what it's called?
I'm sorry?
I didn't know if there was a question that you're asking.
Please
Yeah.
do tell me what it's called.
It's called Cases Cited for MTS, which is Motion to Suppress.
So MTS, was that a motion that your office wrote?
We did not write that motion, no.
Do you know where that motion came from?
It was written by one of Owen's previous attorneys.
And ultimately, the defense did not end up filing that?
We did not end up litigating it. I believe it had been filed by, if my memory serves that, it had been filed by the previous attorney, but we didn't go forward with the hearing, is what I remember.
So in viewing each of those folders, did you view any research for the Eighth Amendment?
No.
Do you recall if you were tasked or asked pre-trial to do any research on the Eighth Amendment?
No.
Did you view any research in those folders that pertain to the computer charge?
I believe there was a file in there called Timeliness Research, and I believe that had to do with it.
So let's take a look at that. I believe that's marked as document 8.
Yep.
And there's actually I'm going to call it a blowout of a, sorry, Judge, may I approach the witness?
Yes.
Just so I can point to what I'm talking about. So there's one line that is highlighted.
Yes.
Can you tell me if that line is a folder or if that is a particular singular document in that folder?
Yes, that's a Word document.
And is that the only document that you see in this folder that relates to computer research?
Yes.
Okay. And what is that document?
That is a memo.
And if you look at the blow up on the side, the properties window, what is the content created date on that memo?
It's October 13th of 2015, and that's also in the file name, so it's consistent.
Do you remember working on that memo?
Vaguely.
Do you remember if you had, I guess I would ask, was it a leisurely written memo?
No.
How was it drafted?
I mean, I guess in the same way the other memos, I believe I was asked to do research on this topic, and then I would do the legal research with Westlaw and write a memo.
Was it a rush order?
Yes, it should have been done quickly.
Do you have number 9 up there?
No.
May I approach, Judge?
Yes.
Thank you. I'll show you what's been marked for ID as exhibit number 9. Do you recognize that document?
Yes.
And is that the memo that was reflected in the screenshot in number 8?
I believe so, yeah.
And what's the date on that memo?
October 13th, 2015.
Judge, I would ask that the ID on exhibits 4, 5, 6, 7, 8, and 9 be stricken and that they be marked for full exhibits.
I think 9 already is, but to the extent that they are, a motion's granted.
I'd rather be overly cautious than miss it like I did yesterday. Thank you, Judge. Do you remember why you were asked to do research on the timeliness of that pleading?
I believe we had filed a motion and then received an opposition from the state, and I believe that this was research in preparation of a response to the opposition.
If you had been asked to do other research on the issue of the computer offense, would it have been in that folder?
In the legal research folder? Yes. If it was something like a memo, yes. Yep.
Was there a folder for each witness in Owen's case?
Yes.
And did you prepare those folders?
Yes.
Was there a folder labeled complainant?
Yes.
Judge, may I approach the witness?
Yes.
Thank you. May I look at your list? Is that okay? I'm showing you what has been marked as a full exhibit, number 3. 2 pages, if you could take a look at those 2 pages and let me know when you're comfortably familiar with it.
I've looked at.
Thank you. So that document includes some photographs.
Yes.
Do you remember seeing those photographs in the time that you were working on Owen's case?
Yes.
And I believe you also have up there exhibit number 2.
I don't think so. I'm sorry.
You don't think so?
No.
Judge Manette?
Yes.
You withdraw.
Yeah.
Okay. Here we go.
Okay.
This has been marked as a full exhibit as well. Can you please take a look at that document and let me know if you know what it is?
Yes.
So if you can take a look at exhibit number 2 for me, what is that?
That is a printout of an email that was sent from Ms. Prout's mom to her.
Do you remember seeing that email and the attachments to it in the process of working on Owen's case?
I believe I did.
Do you have a distinct memory of it?
I would hate to say a distinct memory of. I believe I saw it.
So I guess, is it fair to say that it's not something that you are surprised to see, it's something
No.
that you believe you've seen in the past?
Yes.
Okay. Can you tell me if all of the photographs that are attached to that email are also present in Exhibit 3, which is a screenshot of the complainant folder?
Okay. Some are there, but it looks like not all of them.
Is it fair to say that the photos of Chessie jumping on the trampoline were not downloaded in the complainant folder?
Into the complainant folder. But could I explain it about the complainant?
Please.
The complainant folder wasn't one of the folders that I created for witnesses.
Okay.
Should I talk more about the process of how I created the folders? I'm sorry.
No, that's okay. I'll ask you that in a moment.
Okay.
Did you, I think the word that you used when I asked you about that document, or about the complainant folder, is that you may have been the person who populated it, meaning you may have been the person who put stuff into an empty electronic folder?
Yes, and I don't believe I was the only one who saved things in this.
In the process, generally speaking, if you put items, or if you populated, or anybody in your office populated a folder with discovery, would it be your habit to include the entire document?
So, for example, if it was a police report or something,
Yes.
then yes, we would. Well, if it was a long document, then no. We would put the pertinent parts in it.
Is it likely that it was a deliberate omission of those 2 photographs and adding that to the complainant folder?
No, I do not believe that it was deliberate.
You indicated that you also created additional folders for various witnesses in the case.
That's right.
And did that include potentially additional information for the complainant, who was Chessie in this case?
Yes, that's right.
Okay. And in that folder would have been various documents that could have been used or that related to her?
Yes, the bulk of the discovery materials that had to do with her and electronic communication and things like that, yes, would have been saved in her witness folder, which was, yes, what I created.
And in populating that folder, did you make a decision about what to include and what not to include, or did you just include everything so that could be processed and digested by Attorney Carney?
In the witness folder, it was more inclusive of things, but it wasn't every single thing because that would have been the entire discovery. Yeah.
Do you recall if in working on Owen's case you were provided with captures of the various student email accounts?
That's some, yes, some email.
And do you remember the process that you had to go through to view those emails?
Yes.
Was it laborious?
It wasn't, it was not, it was technical, I guess it would be. It was a special software that we had to install, and it was hard to get it to work properly, I guess.
Did you do any work on the motion to set aside verdict aside from the timeliness memo that you worked on?
I have trouble remembering distinctly, but I believe I probably would have site-checked it, is possible.
Were you asked at that point to do research on anything in addition to timeliness, post-verdict?
I'm sorry?
Post-verdict, were you asked to do research on anything in addition to timeliness that you recall?
If I did, it would have been saved as either part of the draft of the motion or in the legal research folder.
Are you aware of whether anyone else did research on directed verdicts before the verdict in Owen's case?
I don't know.
Are you aware of whether anyone else did research on the computer charge before the verdict?
I don't know directly.
Are you aware, or were you asked to do legislative research on the computer service statute before trial?
No.
Are you aware of whether anyone else did legislative research before trial?
I don't believe so.
And again, generally speaking, if anyone had done it, should be in that legal research folder.
That's right.
Did you have any substantive pretrial conversations with Attorney Carney or Zaganjori about the computer charge?
Substantive conversations? I don't think so.
Can I have 1 second, Judge? May I approach, Judge?
Yes.
Sorry, 1 second. I can help you. These are 2 and 3, and these are 4 through 8.
Attorney Fullerton, I'm going to draw your attention to 4, 5, 6. Four, 5, and 6.
Okay.
I would ask you to take a look at those documents. Those are the legal research screenshots.
Yes.
Can you tell me the date
that those folders were populated?
The dates that the files were created?
Yes.
Okay, because sometimes if somebody accesses them after, the dates will change, because like it says one of the folders was from 2016, and that's not possible. That's not correct.
This is true. What was, are you able to tell by looking at the documents what, so the date modified?
Yes, that's what I'm referring to, yeah.
Sure. I think if you look at the, I would draw your attention to number 5, which is the details, for example, of the opening of the door folders.
Yes, yep.
The date modified, can you read that?
Yes, it's, all of these were saved on August 17th, 2015.
And can you read the date modified for Exhibit 6, which is prior consistent statement details?
Yes, these were all saved or last accessed on August 17th, 2015.
And August 17, 2015 was the date of jury selection?
I believe so.
I have nothing further at this point. I believe the state may have some questions. Thank you.
Cross-examination.
I just have a couple of questions for clarification. You indicated that you tried to mirror the electronic files to the physical files.
That's right.
Is that correct? And then you also testified that the folders may contain only pertinent information, but not all of the information. Is that correct?
Yes.
So I guess my question is just for clarification, was there ever an occasion when you may have conducted research that might not be entered into the electronic file?
For legal research, probably not. That was all saved, and then it would be printed out. It would. So for legal research, the legal research file should reflect any memos, really, or cases cited in those memos if I was asked to pull them.
Okay. And then you just testified to the date of the opening the door, date modified,
Yes.
as well as the prior consistent statements, the date being modified on August 17th, 2015. Does the date modified reflect the date that the folder was created?
Not necessarily. It could be the date that that was last shown. You last opened it. So, as I said before, like some of them are dated 2016 for last modified, and that is not when that was created.
So it's quite possible that these two folders were actually created before the date of jury selection.
That's possible. So if, for example, it was created and then we went back to print the cases or something like that, then that could have changed the date modified. But the date modified is something done through Microsoft Word or the computer itself. It's not something that we would have had any control.
It stands automatically when you go in and you touch that information.
That's right.
Is that correct?
That's right.
Thank you. I have no further questions.
Any redirect?
So I just need to look at one document briefly, and then I can answer that question. I have nothing further. Thank you.
Thank you, Ms. Pickle.
Thank you.
Judge, I would excuse the witness if the state is in agreement.
Granted.
I would ask that she remain under the sequestration order and not discuss with other witnesses.
Okay.
Thank you.
Even if she isn't, the other witnesses are.
I know. I'd like to cover my bases. Judge, we have no further witnesses at this point.
Okay.
Thank you.
Thank you, Your Honor. The state calls Sam Zaganori at this time. and last name for the record, please?
Sure. First name is Samir, S-A-M-I-R, although everybody knows me as Sam. And my last name is Zaganjori, which is spelled Z-A-G-A-N-J-O-R-I.
And many of us are familiar with you here, but just for the record, would you explain what your profession is?
Sure. I'm an attorney. I've been an attorney in Massachusetts since 2005.
And where did you receive your legal education?
I graduated from Boston University School of Law in 2005.
And you're admitted to practice the bar in Massachusetts?
Massachusetts State Bar, U.S. District Court in the District of Massachusetts, and the First Circuit Court of Appeals.
Are you admitted to any other state bars?
No.
Would you just briefly highlight your work experience as an attorney?
Sure. My first job out of law school would have been in September of 2005 after graduation. I was a law clerk with the Massachusetts Juvenile Court, where I was a clerk to the judges of the Juvenile Court, dealing mainly with juvenile delinquency cases and child protection matters. I became an assistant district attorney in Middlesex County in Massachusetts in September of 2006. I stayed there for 6 years. During that time, I started, like most DAs, I started in the district court. I later became the supervisor of the Cambridge District Court. And then my last 2 years in the district attorney's office, I was a prosecutor in the child abuse unit, which is a superior court team that handles child abuse cases. I left the district attorney's office in October of 2012. I went to work at a law firm that was then known as Carney and Basil in Boston, where my primary boss was J.W. Carney. The firm split the following year, and I stayed with Attorney Carney's firm, which was then called J.W. Carney Jr. and Associates, or Carney and Associates. I left Attorney Carney's firm last year and started my own sole proprietorship as of September 1st of 2016, and that's where I'm currently employed.
And just for the record, was your departure from the Carney law firm in any way related to this case or this trial?
No.
Were you working for the J.W. Carney and Associate law firm in August of 2015?
Yes, I was.
And were you retained as trial counsel as part of that firm in the State versus Owen Labrie case?
The firm had been retained with the understanding that Attorney Carney would be lead counsel.
Okay, thank you. And is Attorney Carney, to the best of your knowledge, admitted to practice in the state of New Hampshire?
No.
So therefore, was it necessary for you to have a local counsel file an appearance with you pro hoc vice in order for you to represent this client in New Hampshire?
Yes.
And who was that local counsel?
Attorney Carney ultimately made contact with Attorney Jay Rancourt, who agreed to serve as local counsel.
You testified that Attorney Carney was lead counsel in this case?
That's correct.
And would you characterize yourself as co-counsel?
By the time the trial occurred, I would, yes.
Can you explain that when you say by the time the trial
Sure.
occurred?
Initially, I think the understanding was that Attorney Carney and local counsel would be in the courtroom every day. In July, that changed, and I was selected to be, in court every day. So, with respect to the trial, I was co-counsel.
And Attorney Carney acting as lead counsel, would you conduct your work at his direction?
Yes. With a fair amount of discretion and autonomy.
You were able to work autonomously?
Absolutely, yep.
Were you invited to offer your own input into the case?
Yes.
Was Attorney Carney receptive to suggestions that were offered to him?
Generally, yes.
After the firm had been retained, did you meet with the defendant?
I first met with Owen sort of while the firm was being retained. That would have been in February of 2015. I don't recall when the next time I met with him was, but I certainly met with him, before the trial. Between February and August, I'm sure I met with him at least once or twice, if not more.
And And Your Honor, I really am not familiar if it's necessary for the record, but can you identify the defendant in the courtroom today?
He's sitting at the table on my left. He's wearing a blue striped tie and a dark suit.
Thank you. In your meetings with the defendant, did you discuss his version of the events of the case?
Yes.
Do you wish to elaborate on that any further?
Judge, I would object at this point. I believe that his version of the case is beyond the scope of the implied waiver. His comments and conversations with counsel about his version of events.
I disagree, given the claims that are raised and what's in the affidavit about the defendant's direction of the legal team.
The state's position is that it's relevant to the development of the legal theory and the strategy for trial.
I understood the sentencing because there's nothing in the sentencing about. But in terms of the conduct of the trial, I think it's certainly relevant.
I would ask permission to revisit if
Well,
I think it's
I'm not
appropriate.
going. I mean, you're always entitled to revisit. My rulings are not always right, but I think this is relevant to the claims that have been raised for your motion.
Based on your recollection of your meeting, could you describe, briefly summarize, characterize the defendant's version of the events?
Owen was, I think, consistent then with what he ultimately testified to at trial, which was that he had not met with Miss Prout with the intention of having sexual intercourse. He was always denied to us that sexual intercourse had taken place, and he denied that she had expressed a lack of consent or that he had tricked her. So essentially, he denied that any of the charges were true.
And did he maintain that same position throughout pretrial and trial?
I believe so.
Did you develop a theory of the case?
We did, consistent essentially with his version of events and his desire to go to trial and challenge all of the offenses.
And when you say we did, can you describe collectively who participated in the development of the theory of the case?
Primarily, I would say it was Attorney Carney, myself, Attorney Adanya Fullerton, and to a lesser extent, Jay Rancourt, who was local counsel.
But each of you had some part of the decision-making process, is that correct?
Yeah, to varying degrees, but yes, I would agree with that.
Did your theory of the case ever change?
Not in any material respects that I can recall.
And based on the theory, based on your collective theory, did the trial team develop a strategy for trial?
We did.
Did you discuss your theory as a trial team with the defendant?
Yes.
Did you discuss strategy with the defendant?
Yes.
And did those discussions also include Attorney Carney?
Yes, very much so.
Did they include Attorney Fullerton?
Yes.
And did they ever include Attorney Rancourt?
I believe so, but to a lesser extent.
And prior to trial, did the defendant ever express disagreement with your trial theory or strategy?
Not to my knowledge.
During trial, do you recall if he ever expressed disagreement or concern?
He never did.
With multiple attorneys involved, could you describe your division of responsibilities?
At what point in time?
Well, let's start pre-trial.
Okay. When we were first retained to represent, and when I say we, I guess that's the law firm. When the firm was first retained to represent Mr. Labrie, my first, I guess, task or major involvement was that I drafted an opposition to the state's motion to revoke his bail. So that was my first sort of significant project on the case. As trial approached, Attorney Fullerton was the primary person who reviewed discovery, organized discovery, sort of identified potential either requests for discovery or things that we thought might be missing from discovery. My involvement between, I guess, March and the summer was fairly minimal. As I said, our understanding had been that I wouldn't be trying the case. As the summer approached and sort of trial preparation started to speed up. I took on more of a role in terms of strategy meetings and things of that nature.
And I'm going to ask you to back up to
Sure.
something that you just testified to. You mentioned that your first involvement was in response to a motion to revoke bail. Do you recall at what point in the criminal process your team was retained to represent the defendant?
Owen met with us in February. It took some time before the legal fee was raised. I believe Attorney Carney filed an appearance, I think in March would be my best estimate, and I know that the case was originally scheduled for trial that May, and that was later continued to August.
And were you aware, if at all, whether that trial schedule had any impact on your strategy or your trial preparation?
I don't believe so. Attorney Carney, obviously coming into the case, he needed more time to prepare, but I don't know that our strategy was affected by the trial date, not to my knowledge at least.
And I'd also just like to back up a step and have you clarify. Can you describe for us the process in that firm when a case is opened and how the file is first developed?
Mm-hmm. Every case is different. Our general model, at least at that point, was that either Attorney Fullerton or myself would be sort of the lead associate on a case. We'd do a lot of the background work, would be in constant communication with Attorney Carney, and then as trial approached, Attorney Carney would obviously take a much more involved approach, but typically an associate had primary responsibility to keep track of deadlines and things of that nature.
And what was your primary responsibility?
On this particular case?
Well, yeah, let's start pre-trial from March to early summer.
Mm-hmm.
What was your responsibility?
I really didn't have any, specific responsibility. I was a resource, obviously, if questions came up or if we were having discussions, but I didn't really have any, specific responsibility at that point.
And are you able to answer why Attorney Carney asked you to become more involved with the trial as it got closer?
I can recount sort of what he told me. As the trial came, one, we obviously worked together. We had offices next to each other. We had, I think, a very good working relationship most of the time. He knew that I had been a child abuse prosecutor, and I think he knew my, skills. So I guess as the trial came closer, he would sort of comment that he wished I were trying the case with him, and we were sort of both operating under the assumption that that wasn't feasible. He also would express, dissatisfaction, or he commented that he wasn't impressed with Attorney Rancourt. He didn't think she was bringing much to the trial team, and would sort of lament that I wish I was trying the case with you. At some point, I believe it would have been the end of July, I think he took a look at the Pro Hoc Vice rule, I think it's Rule 19, thought that there was an argument to be made that I could try the case and that Attorney Rancourt wouldn't have to be in the courtroom, and we ended up filing a motion along those lines, which was subsequently allowed.
And that's when you filed your appearance to come on board?
I believe it was that last week of July, through Attorney Rancourt as local counsel.
You spoke to Attorney Carney's awareness that you had been a child abuse prosecutor. During your tenure as a prosecutor, did you encounter computer use charges that were similar to the charges in this case?
Yes, in Massachusetts it's a different statute. It's known typically as child enticement. Different elements, but fundamentally the same crime. And there were a number of cases, I can't really estimate, but it wasn't uncommon to encounter that in either a child abuse investigation or in a prosecution.
So based on that experience, you were more than familiar with those type of charges?
I was familiar with the Massachusetts statute, correct.
And does the Massachusetts statute vary by much from the New Hampshire statute?
The language is different. It's hard for me to say without having them in front of me. The essence of the charge is generally similar. There are differences, specifically, I think, in terms of sort of the enumerated offenses that trigger the statute. But in essence, it's the same crime. And it's the closest we have to the New Hampshire computer use statute.
This may seem like an obvious question, but as you began to prepare for trial, as trial became closer and more imminent, did you also have a division of the workload and the witnesses that would be called to trial?
Yes, almost immediately. Once it was clear that I'd be trying the case with Attorney Carney, we essentially divided up the witnesses, agreed that he would cover certain people, I would cover certain other people, and that was really where most of my focus was in the weeks leading up to trial, along with drafting motions in limine, which I think I took the lead on, and I think I argued most of them.
And did your responsibilities overlap? Did you ever interact with Attorney Carney and share perspective or questions regarding?
Very frequently.
And was Attorney Rancourt ever part of that type of preparation?
She was.
Did you review the discovery in this case?
I did. I didn't review every single page. That was Attorney Fullerton's responsibility, was to look at the bulk of the discovery. I reviewed the discovery that was, I guess, overall most pertinent to the case. And then after that, I focused on the discovery that was relevant to my particular witnesses.
Can you describe in a little more detail how you coordinated that effort with Attorney Fullerton?
Sure. We typically, and in this case we create what are called witness folders, which is, it can be a digital folder, it can be a paper folder, it can be both. I think in this case it was both. And it's just identifying any discovery that's relevant to a particular witness, which would include any written statements, any prior testimony, any police report, really any material where they're referenced in any significant way. So it just condenses all the information about a particular witness and sort of puts it in one place.
So would Attorney Fullerton sort of flag what would be pertinent to the witnesses that you were working with?
She would, and oftentimes as I was looking through the discovery, I might see something that I thought related to another witness, but she was sort of that was her primary responsibility, I guess, or she was the person who was primarily responsible.
And you've already testified that you developed a trial theory as well as strategy for trial. Was your review of the discovery with an eye towards that strategy?
Yes.
Could you elaborate in any
Sure.
way on that?
Everything we did from that point on was with an eye towards trying the case, whether it was, from my perspective, that primarily meant motions in limine and cross-examination. And we did put on our own case, but at least initially, just because the state's case goes first, was focused on developing cross-examination. And what I typically do, and what I did in this case, is I also keep sort of a separate, notes folder, just things that might be relevant to an opening statement or to a closing or just to trial strategy in general. But yeah, everything we do at that point is targeted towards preparing for trial.
In addition to your trial prep, did you conduct any legal research?
I did.
Do you recall in regard to what specific areas?
Certainly before the trial, I looked at the indictments and looked at the statutes under which Owen was charged. I remember looking at the elements of the offenses. I'm sure I did some case law research to go along with that, although I can't really remember specifically what issues I looked at or what cases I looked at. But certainly, one of the first things I always do when I come into a case is identify the elements and then sort of compare that to the evidence.
What was your understanding of Attorney Rancourt's role at trial?
It wasn't clearly defined, but I would sort of characterize it as she was a resource, sort of a consultant. There were specific tasks that she had made herself available for, like jury selection. She was there. She was there for the charge conference. She was there for a lot of the trial. I can't specifically recall which dates she was and wasn't. But she certainly made herself available to us by phone, by email. I know I called her and contacted her on numerous occasions. So she was available to us and was in court. I don't know if it was most days, but certainly many days.
Was she always available to you when you reached out for her assistance?
I would always get a response. It's not to say she would always answer her phone. I'm sure she had other things going on. But
within a timely manner?
She was always very responsive and very cooperative with me, without exception.
And as you may recall, there was a point made that she might not be readily available if needed to be called upon during trial. But did you find that did not become a problem, that she responded in a timely manner when
Yeah,
needed?
I don't recall any instances where I couldn't get a response from her in a relatively, reasonable time period.
So would you characterize her participation as being limited?
Yeah, I mean, she wasn't here every day, so yes, I would.
Did you believe that her participation in the limited capacity as it was effective?
Yes.
You have responded to interrogatories
I
in
did.
preparation for this hearing. In fact, I believe these interrogatories are sworn statements. Just like to talk a little bit about the interrogatories. You testified that prior to trial you reviewed the statutory language and the elements of the charges.
I did.
Did that include the computer offense?
I assume so. Again, I don't really have a specific memory, but I'd be very surprised if I didn't look at all the charges.
And we talked a little bit about the New Hampshire statute versus the Massachusetts statute. But do you recall in your assessment of the terms a computer online service, internet service, or local bulletin board, do you recall what your assessment was in terms of the application of the facts of this case to the statute?
My view of those terms is that they would apply to the allegations in this case. I thought those terms, particularly internet service and online service, were sort of broad, probably intentionally broad, and I didn't think there was any real question that the allegations, if true, would qualify under those terms.
So there was nothing in the statute that caused you to believe that you needed to further research whether these facts applied?
I may have conducted further research, I'm honestly not sure, but I thought the face of the statute, the language in the statute, to me, was fairly clear.
Did you believe there was any constitutional basis to challenge the statute?
Not that I recognized.
Facially?
No.
Or as applied?
No.
And based on that assessment, you did not file any challenges, is that correct?
That is correct.
Do you recall if you looked at any New Hampshire case law construing the computer use statute?
I'd be speculating. I think I probably did, but I can't tell you that I have a specific memory one way or the other.
And again, going back to the language of online service or internet service, at any time did you question whether the intranet versus internet would be an issue?
I didn't look at that specific issue.
And is there any particular reason that you can say why?
My understanding, at the time at least, and I think still is, was that particular computer system was capable of accessing the internet and also sending emails outside of that network. So to me, that qualified under the statute. I know that, yeah, that was my understanding at the time.
Do you care to elaborate? Or?
Well, it's my understanding now, based on some of the pleadings that I've seen, are that there are hours of the day where that's not the case. That wouldn't necessarily change my view of the statute, since it focuses on the system itself as opposed to the communications. But at the time, to me, it was it accesses the internet, it sends emails beyond the network, and to me that fit under the plain language of the statute.
And again, I know you've answered in the interrogatory. I'm just asking these questions to create a record. Do you recall ever reviewing the indictments to determine if there was a need for a bill of particulars?
I reviewed the indictments. I never thought that a bill of particulars was needed in this case.
You didn't find it necessary in order to develop your defense?
I did not.
Since we've been talking about the computer charge, this is probably a good time to talk about the claim of failure to challenge the computer use at trial. Do you recall what your strategy may have been in challenging that particular charge?
Yeah, I think that defense was sort of encompassed in our general theory of the case, which I thought we were fairly consistent in pressing forward, which was that on the night in question, Owen didn't meet up with Miss Prout, to engage in sexual intercourse, but just to have a romantic special evening. I forget how he characterized it, but our theory of the case was that he met up with her that evening, with romantic ideas, but not to engage in sexual intercourse. And our defense was that no intercourse had occurred, and that's consistent, at least to me, with not being responsible under the computer charge statute, because the question would be, obviously, what was his intent when he sent those particular messages? And I thought, went to great lengths to illustrate that his intent at that time was not to have sex.
And can you elaborate on those efforts at trial?
Attorney Carney and I both cross-examined several of Ms. Prout's friends, as well as several of Owen's friends, and I think almost without exception we elicited from them that some of the terminology that was used, whether it was slay or pork, whatever the case may be, that those terms didn't necessarily mean sexual intercourse. That's obviously relevant because it goes to Owen's intent with respect to that meeting. We also challenged whether sexual intercourse had actually occurred, and then I guess most significantly, Owen testified that his intent was not to go there to have sex, which if a jury had credited that testimony, that would have disposed of that charge.
So primarily, the intent was important to you at trial?
With respect to that charge,
with respect to that charge, yes.
That was the critical question, because there was no real dispute as to there's no real question about the substance of his communications with Ms. Prout. The only question was, what was his intent when he sent them?
In that regard, also, you respond in your interrogatory regarding your cross-examination of the DNA expert.
Yep.
And was your cross-examination of the DNA expert made with an eye towards your strategy to question the intent?
Could you rephrase that, please?
Your cross-examination of the DNA expert, was that intended also to raise doubt about his intent?
Yes. The immediate, I guess, purpose of my cross-examination was to explain the presence of what appeared to be sperm. We were trying to show the jury that there might be explanations for the presence of sperm other than sexual intercourse. So that was the main purpose behind that cross-examination. And if you step back, our position was that if you're able to show that sexual intercourse did not in fact occur, then a jury is less likely to believe that that was his intent originally.
And did you have a DNA expert for the defense team available at trial?
He was here. His name was Eric Carita, C-A-R-I-T-A. He was present in the courthouse. I believe he was present during the state's DNA expert's testimony. We consulted with him, and he sort of gave me specifically, bullet points, essentially gave me guidance in terms of how to cross-examine. And we decided that we didn't necessarily need him to actually testify, but rather to consult about areas of cross-examination for the state's expert.
You commented also that part of that strategy was relying on the defendant's testimony at trial.
Yes.
And do you recall his testimony at trial?
I do. Yeah.
And did you feel that it was consistent with his versions of his this incident that he had shared with you previously?
Generally, yes.
I'd like to talk about the claim of selective prosecution. And that also encompasses the theory of jury nullification. Did you have a strategy regarding, let me rephrase that question. In your review of the discovery, did you find that there may have been a reasonable claim for selective prosecution?
It wasn't something that I personally thought was a viable defense.
Can you elaborate on that, why you thought that it might not be?
I guess on one point, generally, I'm not sure selective. I think in general that's sort of a long shot defense, but specific to this case, that in argument of selective, well, one, to my knowledge, there was no comparable instance of someone who had engaged in a senior salute type situation that had resulted in the types of allegations that we had. So one, I didn't think the facts really supported it. Two, I had a concern that if we went down that road of arguing selective prosecution, that might open the door to other factors that could potentially be negative for Owen.
Such as potential 404B evidence?
We were aware that there had been other accusations, or maybe not accusations, but there had been reports of potentially misconduct with, or at least arguably inappropriate conduct with, I believe, at least 2 other females, which we didn't want to open the door to that. We also, that was the main concern.
In your interrogatory, you characterized, if I could read from that, you were aware that other females had reported that Mr. Labrie had been unusually aggressive or physical during sexual encounters. Is that what you're referring to?
Yes.
And did you consider this in your strategy for preparation at trial?
We were very, very intent on trying to keep that information excluded.
Is that because you believe that if that information was admitted, it would be damaging to the defendant?
Yep. Yes, excuse me.
And do you believe you were effective in keeping that particular evidence from being admitted?
To the best of my memory, it didn't come in at trial. We filed a motion to exclude it, which I believe was allowed without objection. And again, to the best of my memory, I don't think any of that came in at trial.
Can you elaborate at all on what you believed could potentially open the door to such 404B evidence?
Specifically, the conduct with the 2 females?
Mm-hmm.
There's an argument, and obviously ultimately it would have been the judge's decision. Mm-hmm. But if you're going to argue selective prosecution, that you're picking on Owen either because of who he is or because of Ms. Prout and her family, then potentially you open the door to the state saying, no, actually we considered X, Y, and Z when we brought these charges. And if X, Y, and Z are not helpful to Mr. Labrie, then that's obviously counterproductive.
Now, you did not do the cross-examination of Andrew Thompson.
I did not.
But were you familiar with a team strategy or trial strategy in regard to his cross-examination?
Generally, I think it fit in with our approach to most of Owen's friends, which was to clarify that the language used wasn't necessarily indicative of sexual intercourse. That was sort of the overarching approach to several of his friends.
And you do speak in your interrogatories as well that you believed it would be strategically unwise to suggest that those witnesses were lying about Mr. Labrie. Could you explain that?
Well, one, these were his friends who really had no motive to lie about what he had said to them. Two, a lot of those communications were in writing, so you really can't, if they're Owen's words in writing, it's hard to argue that the witness is lying about them. And three, Owen, again with us and again at trial, had always owned up to making those statements, but had indicated that he was sort of bragging. So that's the reason we didn't try to accuse those young men of lying.
It would not have been consistent with your trial strategy?
Correct.
And did you also consider whether the discovery contained any potential prior consistent statements of the complainant?
Yes.
Could you explain your review of that?
That was a critical issue for us, that we, and when I say we in this instance, it was specifically me and Attorney Carney, sort of went back and forth about the language he often uses is whether to try the case tightly or whether to sort of open it up. In this case, Ms. Prout had made statements to a young man when she left the building, the Lindsay building, I don't recall his name, and then she had gone back to her dorm and had conversations with 3 of her friends. There may have also been other statements, after that, but those were the ones we were most focused with, particularly the conversations with the 3 friends. If we were to pursue a defense that was that she had, that she had changed her story, later on in the week after her sister found out or after, rumors had spread around campus, that would, I think, almost clearly open the door and allow those earlier statements to be admitted. So that was a decision that we talked about quite a bit. I think we actually went back and forth on, but we ultimately decided that we would try the case, again, to use his terminology, tightly.
Because you did not want those statements to be admitted.
Correct. I viewed those statements to her roommates as harmful, and we wanted them excluded.
Harmful to the defense?
Correct, yes.
And do you believe that you were effective in keeping those from being admitted at trial?
Yes. There were objections from Attorney Carney about the fact that she had the conversations and sort of what did you do in response to that conversation, but I don't think the substance of those conversations ever came in.
I guess maybe it's better if I ask you the question directly. Were any of those statements found to be admissible at trial?
Not the substance of the statements.
I wasn't asking you a big question. I apologize. I wanted to go back and do that better for you. Another claim is failure to investigate the complaining witness's social media.
Mm-hmm.
Could you address that for the court, please?
I know that at some point, and I don't even have a general date range, but at some point Owen mentioned to me and to Danya, Attorney Fullerton, that I believe there were 2 attorneys. They may have been based in New York. He was under the impression that they had social media that was relevant to the case. I think it was Facebook pages or something along those lines, and he had asked if we would inquire. I did inquire, although I think it took me a while to do it. I think it was one of those things that I just didn't do as quickly as I should have, but I did ultimately call. I spoke to the woman, the female, and my memory of that conversation is that she basically said, we don't have anything, you guys have everything that we ever had, and she wasn't altogether very cooperative, but it was conveyed to me that they didn't have anything to give.
But it's your recollection that you did follow up on that request.
I know for a fact that I called and I spoke to a female. It was the female he had referred to me. But like I said, it did take me candidly longer than it should have. I remember I was sitting on my desk for a little while, and for whatever reason, it just was put on the back burner. But I did make that call before the trial.
And again, I understand that you did not cross-examine the victim in this case.
That's correct.
Can you speak to any particular strategy in regard to her cross-examination, even though you didn't conduct it?
Her credibility was central, particularly with respect to the AFSA charges. It was essentially her word against Owen's regarding what actually happened in the Lindsay building. I know Attorney Carney had some statements that she had either made close in time to the incident or maybe since the incident that we viewed as favorable to us. She certainly gave testimony at trial that we viewed as inconsistent with her prior statements, which I thought he impeached her with effectively. And another consideration, which I already mentioned, was to sort of keep it tight and not open the door to these prior consistent statements. But essentially it was to obviously challenge her credibility, point out inconsistencies in her version of events, which I think there were, and to show that, really just to impeach her with prior inconsistent statements, essentially. Yeah.
Are you aware if Attorney Carney intended to exercise any caution to avoid sympathy from the jury for the victim?
He was very concerned about, one, sort of, to use sort of a colloquial term, beating up on a teenage girl. So for evidentiary reasons, he didn't want to go too far, but also there is a potential blowback if you're too harsh with, a young woman or anyone that age. So yeah, that was a concern of his.
And that was a strategy that you were aware of?
Yes.
Could you address the claim of failure to object to misstatements made by the prosecutor in closing argument? And I believe this was in regard to the DNA evidence.
I personally didn't think it was impermissible argument. I thought it was a reasonable inference. Doesn't mean I conceded as true, but I thought it was a reasonable inference based on the evidence. So I didn't think to object. Attorney Carney was the one who would have made the objection, but if I had thought that it was objectionable, I would have passed him a note or whispered to him. I didn't think the prosecutor's argument was unreasonable based on the evidence.
And actually, this claim may relate back to our previous conversation about the victim and her cross-examination. There's a claim of failure to investigate her mental health records. Could you speak to that?
My memory of mental health records is that either immediately before the trial or perhaps during the early days of the trial, we were permitted to review some of her, I don't know if they were mental health records or school records that touched upon mental health issues. There was, I believe, a lobby conference where Attorney Carney indicated that he wanted to go into some of what was in the records, and I think the state ultimately introduced that evidence during direct examination since it would have come out on cross.
And do you believe as a trial team that you made a sufficient effort to locate the documents that you thought would be necessary for your defense?
I would say yes, although I didn't really have any involvement with that aspect of the defense until probably July when I came into the case, so I really can't speak to what happened really before July 31st. I mean, I was involved in the case, but that wasn't really part of my area of responsibility.
So you wouldn't have filed a motion earlier because you weren't directly involved?
I don't know what I would have done at that point, but based on the records that we saw, I felt that we sought to introduce the parts that had value, and they were admitted.
And again, did that speak toward a caution not to gain sympathy for the victim?
That may have been part of it. I honestly don't recall us discussing that aspect of it. I remember looking at the records. I thought there were things that were clearly not admissible. Would have been, arguably frivolous to try to introduce some aspects of it. The parts that ultimately came into evidence, I thought those were the ones that should be admitted, and they were.
And do you recall, you may not, but do you recall a court order restricting your use of those records at trial?
Well, there was a protective order with respect to viewing the records and not disseminating the contents of the records. Is that what you're referring to?
Do you recall that Judge Smuckler ordered that defense was not to refer to those records without seeking prior permission from the court?
I believe that's correct, yes.
And one other question in regard to the witnesses. Were you present for a Richards hearing that happened prior to any of the witnesses from St. Paul School testifying in the trial?
I think that I was. I believe I was, if I'm thinking of the correct event.
Was it your understanding that there may have been Fifth Amendment issues for some of the witnesses?
Yes.
And can you speak to that?
I'm not sure I actually have a specific recollection. I think it may have been some of the young men involved and some of the activities that they may or may not have engaged in. I don't have a real great memory of that. I don't think I was the lead attorney with respect to any Fifth Amendment hearings.
Is it your understanding, however, that any potential Fifth Amendment issues had been addressed prior to their testimony?
As far as I can recall, but I'm honestly not, I don't have a great memory of really any Fifth Amendment issues being contested or raised.
I'd like to talk about the jury instructions.
Counsel, if this is a good, you want to do another area, maybe we'll take a mid-afternoon break.
Certainly, I don't have too much longer, but if you'd like to take a break now,
That's fine.
I
If
can
you're only
finish
going to
up.
be a few minutes, I didn't want to cut you off.
I don't intend to be much longer, Your Honor.
Okay, go ahead.
But I'm happy to break and
It's up to you.
resume. Why don't we take a break and resume? That's fine.
Okay.
Thank you.